Role of mediator in ADR proceedings. Introduction. Alternative dispute resolution, ADR, has emerged as a dynamic and preferred method for resolving conflicts outside traditional courtroom litigation. Central to the success of ADR, especially in mediation, is the pivotal role played by the mediator. This comprehensive note explores the intricate responsibilities of a mediator in ADR proceedings, examining the skills, techniques, and ethical considerations that define their practice. Through real-world examples, we will delve into the nuanced scenarios where mediators facilitate communication, foster collaboration, and guide disputing parties toward mutually satisfactory resolutions. The mediator's role in ADR proceedings. 1. Neutrality and impartiality. The bedrock of a mediator's role lies in maintaining unwavering neutrality and impartiality. In contrast to legal advocates or judges, mediators do not advocate for any party's interests or impose decisions. Instead, they serve as neutral facilitators, ensuring that both parties have an equal platform to voice their concerns and contribute to the resolution process. This neutrality creates an environment where disputing parties feel heard and understood, laying the foundation for cooperative problem-solving. Example: in a commercial dispute between a supplier and a buyer, the mediator refrains from favoring either party's contractual interpretation. By neutrally guiding the discussion and reframing issues, the mediator helps the parties explore common ground, leading to a compromise that benefits both in terms of future business relations. 2. Facilitating communication. A mediator's paramount function is to dismantle communication barriers that often underpin disputes. Misunderstandings, miscommunications, and a lack of effective dialogue can escalate conflicts. Mediators employ active listening skills to comprehend each party's perspective thoroughly. By facilitating open communication, summarizing concerns, and guiding structured discussions, the mediator helps parties gain insights into each other's positions, fostering an environment conducive to cooperation. Example: in a community dispute over noise complaints, the mediator identifies that the underlying issue is a lack of communication between neighbors. By employing active listening and facilitating a community meeting, the mediator encourages dialogue, enabling neighbors to express their concerns and collectively devise noise reduction strategies. 3. Building trust and relationship. Successful mediation hinges on the mediator's ability to establish trust and rapport with disputing parties. Building a trusting relationship encourages open communication and increases the likelihood of reaching a mutually agreeable solution. Mediators deploy interpersonal skills such as empathy, patience, and cultural sensitivity to create an atmosphere where parties feel safe expressing their concerns without fear of judgment. Example: in a family inheritance dispute, siblings may harbor deep-seated emotional grievances. The mediator acknowledges these emotions, building trust by validating each sibling's perspective. This trust enables the mediator to guide the family toward a resolution that addresses not only legal aspects, but also the emotional underpinnings, fostering a more enduring agreement. 4. Problem-solving and creativity. Mediators are catalysts for creative problem-solving. They assist parties in generating options and exploring alternatives beyond traditional win-lose scenarios. By encouraging a focus on interests rather than positions, mediators help uncover common ground and innovative solutions that may have been overlooked in an adversarial context. This collaborative problem-solving approach enhances the likelihood of a lasting and satisfactory resolution. Example: in a workplace dispute over team dynamics, the mediator explores creative solutions such as restructuring responsibilities or implementing team-building exercises. By shifting the focus from fixed positions to shared interests, the mediator helps the parties devise a solution that not only resolves the immediate conflict but also enhances the overall work environment. 5. Managing power dynamics. Power imbalances can significantly impact the mediation process. Mediators must be attuned to these dynamics and employ strategies to level the playing field. This may involve providing additional support to the less powerful party, structuring the mediation process to ensure equal participation, or addressing issues of intimidation or coercion. Effectively managing power dynamics contributes to a fair and equitable resolution. Example: in an employment dispute, the employee may feel disadvantaged due to concerns about job security. The mediator recognizes this power imbalance and ensures a safe space for the employee to express their grievances. By addressing the underlying power dynamic, the mediator helps both parties collaboratively devise a resolution that acknowledges the employee's concerns, while meeting the employer's needs. 6. Confidentiality. Mediators uphold strict confidentiality to create an environment where parties can openly discuss their concerns. This confidentiality instills trust and encourages parties to be more forthcoming during mediation. However, it also presents a challenge in situations where legal or ethical obligations may require disclosure. Mediators must navigate these complexities, ensuring that the confidentiality of the process is maintained while adhering to legal and ethical obligations. Example: in a workplace mediation involving allegations of harassment, the mediator must balance the need for confidentiality with the duty to report such incidents to the appropriate authorities. This delicate balance ensures a fair and just resolution while upholding ethical standards. 7. Impartiality versus advocacy. The mediator's commitment to impartiality sometimes raises questions about their role in advocating for fairness. While mediators do not advocate for any party's position, they advocate for a fair process. Balancing this fine line requires nuanced judgment and a keen understanding of the underlying dynamics. Mediators must resist the temptation to take sides while ensuring that each party feels heard and respected. Example: in a divorce mediation, the mediator does not advocate for either spouse's desired settlement terms. Instead, they advocate for a fair and equitable process that allows both parties to express their needs and concerns. 8. Cultural sensitivity. Mediation often involves parties from diverse cultural backgrounds, each with unique communication styles and expectations. Mediators must be culturally sensitive, recognizing and respecting these differences. Failure to do so can hinder effective communication and compromise the integrity of the mediation process. Example: in an international business dispute, cultural nuances may affect how parties express themselves. A mediator with cultural sensitivity can bridge these gaps, ensuring that the parties understand each other's perspectives and work towards a culturally informed resolution. Conclusion: in the realm of alternative dispute resolution, the mediator emerges as a key player, connecting the threads of communication, trust, and creativity to fashion resolutions that stand the test of time. Their ability to navigate the complexities of human emotions, power dynamics, and divergent interests is pivotal in transforming conflict into cooperation. Looking forward, the integration of technology and the establishment of robust professional frameworks will shape the future landscape of mediation. As individuals, businesses, and communities seek more collaborative and efficient ways to resolve conflicts, the mediator stands at the forefront, embodying the principles of neutrality, impartiality, and creativity. In a world where the resolution of disputes is not just a legal necessity but a pathway to sustainable relationships, the mediator's role remains not only relevant but increasingly vital.